My name is Leslie Bruno. I'm with Dominion Payroll, and this is our every other week HR Matters webinar where we look at issues of human resource, issues with your personnel and human resources related topics. We started these, several months ago, and we've had a lot of fun with all of you. You guys have had some great questions. So we're excited to kick off our first HR Matters series of 2021. Happy New Year to everybody. And my very special guest today is Courtney Malveaux, attorney at law with Jackson Lewis here in Richmond. Good morning, Courtney.
Good morning, Leslie. How are you?
I'm well. How are you?
Life is good. I'm here on the third floor of my home. Barking dog, children, online class and all, but we're 2021 is looking up, and there's a path forward.
That's right. Some things stay the same and some things change. Our topic today is definitely a 2021 topic, although the vaccines were approved in 2020 and the trucks began rolling out. This is going to be an ongoing topic of discussion for businesses, large and small, throughout the country. And so we thought we would start out HR Matters in 2021 with what we know about vaccines in the workplace. As always, there are still some gray areas and things that we don't know going forward, but we're going to do our very best today to disseminate the information that's out there from government agencies, as well as to answer your questions to the best of our ability. And we recognize that the vaccine will most likely not be available to the general population for a little while now, but it never hurts to be prepared and to educate yourself about what you as the employer can and can't require or ask of or encourage your employees to do in terms of vaccines in your workplace, and what your responsibilities are to yourself and to your team. So that is our goal today. And Courtney, I've asked Courtney to join us because he is very well versed in workplace issues. In fact, he's the co-leader of Jackson Lewis's Workplace Safety and Health Practice Group. And in addition to that, represents employers who have been cited by OSHA or other agencies. He's also advises employers in a variety of employment law matters, retaliation, discrimination, unemployment benefits, and wage claims. So he's definitely well-versed in those areas. And then he also is a former director. He was Virginia's labor commissioner. So we're very happy that he had the time to join us today. I know you're busy, Courtney, but we appreciate it.
I appreciate the opportunity to share with you. And as you mentioned, there's a lot of variables that are happening. The good news is that there is good news, and there's light at the end of the tunnel, and the vaccine is going to be a big part of it. But I think since March, for many of you, we've had to encounter more questions than answers and be very flexible and learn as we go. And the vaccine will be no different. And so, that we have some answers. I think we'll leave this without all of the answers, and I think we'll have to once again be okay with that. But it's good to at least know the issues that we need to think about as the vaccine comes online. So I appreciate the opportunity.
Yeah, for sure. And that's a great segue into what I'm putting on this slide, which is that the Equal Employment Opportunity Commission has updated its vaccine guidance specifically for COVID as of December 16th. And every morning I go on to their FAQ page and refresh, and it hasn't been updated since, but we expect, as with all things pandemic, for additional guidance from both the EEOC, the CDC, and other agencies that might be involved with how the vaccine plays out in practice. So today's information is based on the December 16th, 2020 guidance from the EEOC. But like Courtney said, there's a light at the end of the tunnel. And so that is a good thing. We feel good about that. And the fact that they have this information up already means that they clearly are prepared to guide us through this rollout.
Yeah, and I'll tell you that EEOC information, that was a great initial bit of information for all of us. Agencies that are key to look at, EEOC, you may see additional guidance coming out. You may see guidance coming out from OSHA or from state OSHA plans, like in Virginia. CDC, of course, we're all keeping an eye on. But another area where a lot of folks don't see is the executive orders or the various state and local agencies. So there are a lot of different places to look at. And there are blog posts. I know we have blog posts that we can share that at least give you an alert. Okay, new guidance has come out from this agency. Here's what we make of it. So we'd like to be a resource to you, but there are so many different sources to look at. I don't envy you in having to do that. I don't. But we do the best we can to try to highlight what you really do need to know.
Right, exactly. And today's, just because we're focusing on the EEOC today doesn't mean that the other agencies that Courtney mentioned aren't also going to update things. And they all sort of have different jurisdiction. So just as a reminder, I put up here the related acts that the EEOC does enforce. So you all are familiar with the ADA. There's also Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, and then the Genetic Information Non-Discrimination Act. So that's their wheelhouse. And so today we'll be focusing mainly on how the COVID-19 vaccine intersects with that first bullet with the ADA, because that governs privacy and confidentiality, medical records and examinations, and also exemptions. So the big question I've been getting so far is, what happens if I have an employee who objects to the vaccine for whatever reason? What am I allowed to say or do in that situation? So that's going to be our focus today. But of course, we'll take questions from wherever you're coming from, and we'll do our best to answer them. I will say, I forgot to say one quick housekeeping note. If you could submit your questions using the Q&A feature and not the chat, that'll allow me to monitor them a little bit better. And we might answer them during the presentation. We might wait to the end. We'll see how, what the timing looks like. We have about 17 slides today. They are going to be a little wordy, and as usual, I end up putting more words than you're probably used to, but because these are available on our website after the webinar closes today, I want you to have all the information in the PowerPoint deck. We'll also have the recording available too by close of business, so you'll have our answers to your questions there as well. All right. So we're going to dive right in. So like I said, we took these from the EEOC has an FAQ page for all things COVID, and the vaccine is the newest section of that page. There are other sections of that page that are worth checking out. But today we're going to look at the Q&As, some of the Q&As on that section. And I see there's some questions coming in. If you'll hang tight, I believe we will address the questions in the queue right now as part of these slides. But the first topic is really about whether or not asking someone to take a vaccine is a true medical examination under the ADA. So the question posed here is the administration of a COVID-19 vaccine to an employee by an employer or by a third party with whom the employer contracts to administer a vaccine considered a, quote, medical examination for the purposes of the ADA? And the answer is no. A medical examination is defined as a, quote, procedure or test usually given by a healthcare professional or in a setting that seeks information about an individual's physical or mental impairments or health. Examples include vision tests, blood, urine, and breath analyses, blood pressure screening, cholesterol testing, and diagnostic procedures such as x-rays, CAT scans, and MRIs. So what they're saying here is that if a vaccine is administered to an employee by an employer for protection against contracting COVID-19, the employer is not seeking information about an individual's impairments or current health status, and therefore it is not a medical examination. So Courtney, what do you have to say about that? Is that something that's pretty clear cut for you, or do you think in practice that might be, I imagine there might be an employee out there who might object based on maybe thinking that it's a medical examination to get a vaccine?
No, not really. I think it's fairly clear cut. I think the issue that is around the corner is when you give the test, or I'm sorry, when you give the vaccine, then the questions that you have to ask in terms of screening, and then you start getting into much more murky territory. And so, did I segue well for you there, Leslie?
You sure did. Gosh,
Okay.
It's as if we rehearsed. Right. So that is the more specific, perhaps complaint you might get from employees or pushback is that, the screening question. So, have you had COVID yet? Have you had a flu shot? Do you have allergic reactions to vaccines in the past? Are those questions subject to the ADA standards for disability related inquiries? And again, we're talking about an instance where you actually administer the vaccine to your employees, or you contract with a third party, like a health clinic, to administer the vaccine. So that, let's keep in mind, that's the scenario we're talking about here. And the answer there is yes. Pre-vaccination medical screening questions are likely to uncover information about a disability. This means that such questions, if asked by the employer or a contractor on the employer's behalf, are disability related under the ADA. Thus, if you're requiring an employee to receive the vaccination administered by you or a third party that you are paying to do so, you must show that these disability related screening inquiries are, quote, job related and consistent with business necessity. To meet the standard, you would need to have a reasonable belief based on objective evidence that an employee who does not answer the questions and therefore does not receive a vaccination will pose a direct threat to the health or safety of her or himself or others.
Yeah, so and if I can, go ahead.
No, I was going to say, please unpack that for us.
Well, take me, for example, okay? I mean, I'll put it out there. I have allergies. Right now in January, I can breathe a little easier. In a few months, life's going to get tough. And then asthma kicks in. And look, I'm a lawyer. I work in an office. If I'm not here on the third floor of my house, and so does that really matter much to clients or to other lawyers? No, not really. But then again, if say I work for a manufacturer and I'm exposed to certain inhalants or the particles in the air, then if I am asked and I reveal that information that I am asthmatic and have allergies, especially if I were someone who had asthma attacks, then revealing that information could lead a supervisor or foreman to say, hey, wait a minute, you have asthma? Wait a minute, we have these fumes over here, we have those inhalants over there, we have dust, we have all kinds of things. Are you sure you should be here? And so, but for the questions that you're asked in connection with the vaccine, your employer wouldn't have known. And, look, asthma is potentially a disability. It can debilitate you. And so then that could trigger questions or a scenario where you have to start discussing other potential hazards out there and whether reasonable accommodations are necessary. So sure, that's a big one under the ADA. And another area which it falls, you wouldn't think that sex discrimination would be a factor, but if an employee were pregnant and then had some thoughts of concerns relating to pregnancy and taking the vaccine, should that employee need to answer those questions to an employer? And as you said, excuse me, as you said, if the employer is asking the questions and that information is revealed, then, of course, then you might get into a discussion about their essential job functions and whether reasonable accommodations are necessary. So sure, that's really where it starts to get sticky for employers.
Right. And again, this is if you're requiring an employee to receive the vaccination administered by you or a third party. And so we're going to talk a little bit in a minute about whether it's a scenario where you're not requiring it, you're just suggesting it or asking if they've got one maybe at their local Walgreens or something like that. So, and I'm not really clear on, who determines the screening questions. If say my company contracts with Better Med to bring a van to our parking lot and lines us all up, does Better Med determine the screening questions? Does my leadership need to do that? That's the point where I'm not clear. I mean, I get a flu vaccine every year, and there are a couple questions on there.
Mm-hmm. Yeah.
But I don't have clarity around where the questions actually originate.
Sure. And so I I'm a lawyer. I know when to stay in my lane, and asking health-related questions is not something I'm competent to do. And so many of you might be in the same boat. And so if you do contracts with a third-party provider, then ensuring that it is a licensed provider which is competent to do so, then it would and should have the questions that are necessary and provide the screenings. And so, and also, and again, I don't do, now another thing I don't do is civil liability, but I will say that certainly if you start to inject yourself into the expertise of another, if you lack that expertise, do you open yourself up to potential liability if something doesn't go right with the administration of the vaccine or the screening questions? And so, it's a long way of saying staying in your lane can be a very good thing. Now, there are employers that do have competent licensed medical professionals on staff, on site, can do it, yes. But there are landmines, and certainly adhering to those questions that you need to ask for that vaccine is something that should be left to medical professionals.
Okay. Let's go on to the next slide, which sort of tacks onto this. So there are two circumstances in which, this is again from the EEOC, two circumstances in which disability-related screening questions can be asked without needing to satisfy the job-related and consistent with business necessity requirements. So here it is. If a vaccination is offered on a voluntary basis, the ADA requires that the employee's decision to answer the pre-screening questions also must be voluntary. So if an employee, in this case, if an employee chooses not to answer these questions, the employer may decline to administer the vaccine, but you may not retaliate against, intimidate, or threaten the employee for refusing to answer. And then the second scenario here is if an employee receives an employer-required vaccination from a third party that does not have a contract with the employer, such as a pharmacy or other healthcare provider, that job-related and consistent with business necessity restrictions would not apply to those screening questions. So the plot thickens a little bit there. You could require vaccinations, but not offer them, in which case you're sort of out of the screening question dilemma, as it were.
Right. And so we're at a point now, and this is a good place for employers to really start to see, look, the calendar is flipped. The vaccine is out. We're moving from emergency use authorization into a phase where it's going to be more broadly administered very soon. I believe I'm just getting that from just reading the news like anybody else. And so as we move into that, we're at a sweet spot where we can actually start to anticipate. And so and I say we, my firm, the good thing for me is that I don't have to speak with just my own personal brain. I have the wisdom of 1,000 lawyers that I can kind of draw on. And so I go to them for the expertise. And Many of them are putting together policies for voluntary administration of the vaccination, and also for mandatory. I will share casually that it seems like a lot of employers, for the reasons that we're getting into here, are opting more toward voluntary. And so, and now, of course, this is a very, very complex issue that requires a lot of looking at discussion, especially if you want to go down the path of mandatory. But if you go with the voluntary vaccination, then you're not requiring employees to answer questions about pregnancy, about religion, about disabilities, any of that. You're not requiring it. And if you don't require it, and the employee says, hey, I don't need it, I'm good, thanks, that's the end of the discussion. And you have not gained information or asked for information that could get you into other areas of law, especially in discrimination. So that's one huge reason. And so more conservatively, many employers are looking at potentially voluntary, going with the voluntary route. And so, in the title of the presentation, we say, is mandatory possible? And the answer is yes. Well, EEOC provides a pathway for mandatory, but it does have landmines along with it. And that is, of course, one thing I should mention is that, again, you really have to look at what is there state law coming down the pike? Is there are there in terms of localities, are they potentially instituting requirements? Because we've seen that with COVID with respect to testing. We've seen that. And we've seen that with respect to many other requirements in terms of workplace safety. Well, now we're getting to vaccines. And so the states and the localities may play a role. The last time I checked, the General Assembly of Virginia has not had legislation introduced on this subject, although who knows, maybe something was dropped in the bin yesterday or today. But the General Assembly is convening next week, and they probably will wrap up by the end of next month. And so there may be Virginia law on point if the governor doesn't step in and with any additional thoughts in terms of mandatory vaccinations. But based on what EEOC says, the voluntary is a path, voluntary is a pathway. And here's one reason why a lot of employers are choosing voluntary over mandatory. And so, and then again, of course, if you have someone else asking the third-party questions, and if that is information that's shielded away from you as an employer, then you're good. So you may see, of course, treated kind of like you do, I hope you are, if you're screening for temperatures. If employees come into your work site, some of you are screening temperatures. If you screen for temperatures, then what you want to do is you want to make sure that you're separating physically by a barrier, sound, so that an employee is taking the test for temperature or any other medical screening that is not in earshot and separate and apart from anyone else, so that their privacy is safeguarded. Same thing here. So if you do bring in a third party and they're screening, then I would certainly make sure that that screening is done privately and outside of the hearing or the notice of you or others, because their medical information is theirs. And if you decide to make their medical information yours, then you do bring in much more responsibility.
Yeah, good point. And also back to the required versus voluntary decision. I mean, I think part of that decision-making matrix for these organizations is to look at, we have a variety of industries represented on this call, and you have to look at the essential job functions of your workplace. And if you're a healthcare provider or in education or some of those fields where it might be company policy from top down to require it because you're patient facing medical providers. So that's sort of one end of the spectrum, and then the other end of the spectrum is a financial services company like Dominion Payroll, where 95% of our jobs can be performed remotely. And so I would imagine, Courtney, that's part of that decision-making process for employers. And indeed, we have a question here in the queue about from Marty, who says, do you think Virginia OSHA will mandate mandate a vaccine in dental offices and in the medical field. I'm assuming they have not yet. I don't know the answer to that question, but certainly those are the fields where you likely would see someone leaning towards that required vaccine stance.
Yeah, and Marty, thank you for your question. And so Virginia, OSHA and Virginia VOSH, we have our own state program and we incorporate the OSHA regulations and standards by reference, but then of course we have about a couple dozen specific Virginia specific standards. I will just speak from having served as commissioner of that agency, and I would be surprised if it took a step like that. And I would be especially surprised if it took a step like that independent of federal OSHA. Now, if OSHA, federal OSHA, which governs OSHA generally in all the states, OSHA governs except where the states step in and are kind of deputized to run their own program. And so that's about half the states. If OSHA came out with something like that, then it's much more likely that Virginia would take a look at it. But I think I would, at this point, be surprised if OSHA did either. OSHA's focus right now is on a federal emergency temporary standard for COVID-19 generally. They're focused on the guidance. They're focused on a number of different things, but this has not been a focus for OSHA. So, but again, we're keeping our eyes and ears open.
Okay. What about the Virginia Department of Health? Do you have any, can we read the tea leaves and see what they might come out with in terms of a vaccine?
That is a little different. It's more independent than I think Department of Labor and Industry would be, or VOSH. And so I think it's going to take cues largely from CDC. It's, of course, going to keep an eye on EEOC. And that will probably, if it did come into play, would, of course, come to play more with healthcare providers. So that's more of a question in my head, and I don't know the answer to that. So VDH's authority is not only over employees, but also in terms of care. So the jurisdiction is a little different from labor and industry, which governs employees only.
Right. And of course, we are speaking to you all from Virginia, and we realize that there might be some out-of-state folks on this call. In fact, I know there are. So it's worth looking at your state agencies as well. I know that it's a long list between federal and state, but like we said earlier, they all have slightly different jurisdiction. Marty follows up by saying, we are now required to have a Hep B vaccine. I'm assuming, Marty, you work in the dental or medical fields. So that's interesting. So it sounds like you already have some vaccines that are mandated for your employees.
And Leslie, you have some slides past this that kind of address considerations, at least, I think, that will come into play in terms of necessity. And so, while the analysis is not going to be the same, but for VDH, I think that a lot of those factors are going to be very similar. Yeah, so go ahead.
Oh, no, I was just going to say, why don't we see what those slides say? And and I think we're going to get into a couple more of nuances around these same questions. But I didn't mean to interrupt you if you had another thought on this slide.
Oh, yeah. One thing I was going to mention, this is really more from the experience of the firm and in interacting with thousands of employers on their questions. And, we're kind of helping them to develop their policies, both for a voluntary vaccine program and also their plans for a mandatory. And so there's a whole litany of complex questions, and we have to kind of discuss with them, not only to determine whether to go with voluntary or mandatory, but also how it would look and who would apply to. And there's a lot of nuance there. So it's a very complex discussion that we don't have time for here. But I would highlight, though, that a lot of employers, a lot of the concerns that are raised in making this decision, there's employee morale issues, there are dissents, there's dissension. So if you have look, even if your culture is very safety focused, and everyone's masking it up and doing what they can, I would certainly anticipate having at least one or two, if not several, employees who are going to dissent for various reasons. You may have a union you have to deal with, so there might be union organizing. There might be having to go back, and you may not think about this right now, but if you have collective bargaining agreements that you have to go back and revisit, so you have to look at that, and also the conversations often include, what if you have an adverse reaction, and if you have a workers' comp issue, or what if you have a workers' comp issue because someone declined, and then there was a suspected transmission from one employee to another, and the employee is seeking workers' comp for that. So a lot of those, we're having those discussions with a lot of folks. And so not only the question of as to whether or not to go voluntary or mandatory, but also how, it's a very complex question. And so those are a lot of the factors that we're seeing that really come to that conversation. That's all I was going to add.
Well, no, that's a really good point. And I've heard questions about from employers who say, can I be liable if we don't require the vaccine and then someone does contract COVID? Can they fault me for that or file a claim of some sort? I don't know if I have the answer to that.
Well, I'm not a workers' comp lawyer, so I'm putting that out there. I'll just see generally that workers' comp would, there have been, I understand, a couple thousand work comp claims in Virginia last time I checked on COVID-19. And so generally, it seems that our workers' comp commission and from other states are looking at it as an ordinary disease of life. In other words, something that, look, it's something that is out there. It's community spread. It's it's a virus that is everywhere. It's a pandemic. The prefix means it's everywhere. And so, generally, to get over the hurdle of proving that it was you got it from work as opposed to from the community, it's a very high standard. It's what we call clear and convincing evidence. The employers, the employee generally has to prove, at a very high level that this really did come from work and not from home or from the grocery store or wherever. So we are seeing that there's a minority of cases, a very small minority of cases, in which workers' comp claims have been successful in terms of COVID. But that's simply a snapshot of where we are right now.
Right. Okay. And maybe not the best, maybe not at the top of the list of whether or not employers should decide to go voluntary or required in terms of the vaccine, fear of liability, but we'll get into that in just a second too, especially we've got a couple slides here about people who are dissent from getting the vaccine. So we'll get into that in just a second. Francesca shares with us as a school administrator, VDH is actively working, Virginia Department of Health is actively working to get the priority groups lined up for the vaccine. We are in phase 1B, for example. So thank you, Francesca, for sharing that. So that's another listener supplied anecdote of what's going on out there in practice. So it sounds like the education community is working with VDH to get the vaccine rolled out in a way that makes sense for that sector. All right, I'm going to go ahead and advance here. Just a quick reminder while we're talking about these things is that if you do end up shaking loose any employee medical information in the course of the vaccination program, you need to keep it confidential. So like Courtney said earlier, certainly the actual act of screening and administering the vaccine, or even if you're just taking temperatures, needs to be carried out in a place that's outside of earshot or any other way that other employees could be privy to that information. But then if you keep anything recorded, you should keep that in a separate file from the person's regular personnel file. And that's actually best practice in general, COVID or no. to keep sort of the normal personnel file, which is, resume, onboarding materials, things like that. Keep that information separate from the actual medical information, so that anyone who
OSHA
goes,
requires it too.
so it's not a best practice, it's a requirement. So that's because if, say a manager is searching for a performance review from 2019 and they go into that regular personnel file, they don't stumble across any confidential medical information.
Mhm.
So I just wanted to throw that out there as a quick reminder. Okay, so this question is about if you are asking or requiring, so if your employees are been directed by you to go get a vaccine elsewhere, so not on site and not as part of a third-party contractor, can you ask them to provide proof that you actually got that, that got the shot at CVS? Does that qualify as a disability related inquiry?
Mhm.
And the answer is no. So the EEOC is saying here that there are many reasons that may explain why an employee has not been vaccinated, which may or may not be disability related. Simply requesting proof of receipt of a vaccination is not likely to elicit information about a disability and therefore is not an inquiry. However, if you push on that a little bit and start asking why an individual did not receive a vaccination, that might uncover some information that is covered by the ADA, and that's going to get you into some riskier territory. You could sort of mitigate against that. The second paragraph here suggests you may want to warn the employee not to provide any medical information as part of that proof. So that's sort of the answer is technically no, but it could be yes if you go too far down the path of inquiry.
That's actually a great practice for lawyers. I wish we all remember that. You ask the question you want the answer to, and you stop asking questions. You never ask the question you don't know the answer to, and that's depositions, that's trials, and now that's here. You don't ask the question if you don't want the answer.
Right. So that's a good rule of thumb. And I mean, I think what there's, if I can read between the lines here, they're saying that you can ask a yes or no question. And if the answer is no, and your employees are required to get it, then you can say, okay, well, the policy is this, and we're going to ask again for the proof. We won't ask why, but, and then, you can make it certainly if you're requiring the vaccine and they're to get it off site, make it easy for them to get it. Let them go during business hours, pay them for that time. I've heard of some people actually incentivizing employees with little, gifts or gift cards or something like that, or certainly giving them some time to go take it. And if they have any adverse reactions, giving them time to recover. So I've been hearing some of those anecdotes as well.
Yeah, and be careful with incentives, because they can be looked at two ways. They can be looked at as incentive. They can also be looked at as discrimination against those who do not due to a disability.
Right. Yeah, that is true. That's a very good point. Well, I've had some employees ask me, if I don't get it, is it going to be very apparent? Am I going to miss out on something good, like an incentive, or am I going to be the only one wearing a mask? And so it's kind of like a scarlet letter that I'm wearing, walking around. I don't know that, from what I've seen from the CDC, just because somebody has a vaccine doesn't mean they all automatically can go back to the way we all were in early 2020 and prior, in terms of hanging out close to people and not wearing masks. I think the jury's still a little bit out from the public health sector about at what point does that behave? The social distancing and mask wearing truly end? So my guidance to folks is that I'm not really sure that the mask, I don't know that you would be the only one wearing a mask if you didn't get the vaccine, because I think that mask wearing is going to continue for at least a little while. But Courtney, maybe you've heard differently.
Don't hold your breath on any easing of the restrictions, especially in Virginia. So one thing I do in my spare time, which I don't have any I serve on the Safety and Health Codes Board, which enacts the Virginia standards for COVID in the workplace. And so our board, we have, and you may have heard, an emergency temporary standard, which we discussed months ago. It's being replaced potentially with a permanent standard this month. Well, we'll see what happens, but the board is considering a permanent standard next week. And so you may, and that's going to, so far the draft does include all the same restrictions we've been having. I don't think CDC is going to change its tune soon. And you saw Dr. Fauci was saying that, you know, to achieve, you know, community immunity, the number is very, very high. And so I'm just saying, given all, I wouldn't start looking at, you know, pulling back on restrictions or face coverings. I wouldn't do that right now at all.
Okay, good to know. Thank you, Courtney. Okay, so now we're getting into exemptions. This first one is related to a disability exemption. So if an employer requires vaccinations when they are available, how should it respond to an employee who indicates that he or she is unable to receive the vaccination because of a disability? And the answer is, where I'm going to lean on Courtney here to help unpack this, but I'm going to read through it. The ADA allows an employer to have a qualification standard that includes, quote, a requirement that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. However, if a safety-based qualification standard, such as a vaccination requirement, screens out or tends to screen out an individual with a disability, the employer must show that an unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. So examples we've used already here are maybe somebody is pregnant and that qualifies as a disability for not getting the vaccine. The answer goes on to say, employers should conduct an individualized assessment of 4 factors in determining whether a direct threat exists: the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. Now, Courtney, how would an employer go about determining those 4 factors?
Well, again, that's a very complex conversation, and it's very fact specific, of course, and we have to look at the case law and how the courts actually apply these. This language is applied in case by case, in you know, fact scenario by fact scenario. Oh, and by the way, pregnancy, hate to kind of correct, but generally, so yeah, well, not generally, pregnancy wouldn't be necessarily viewed under the ADA, but rather as sex discrimination. So,
Okay.
but again, the reasonable accommodation inquiry and that back and forth conversation is very much similar, but just a different area of the law.
No, good to know.
So, you know, direct threat, you can't, it has to be reasonably objective. Reasonable, it has to be, you know, through objective criteria. It has to be reasonable objectively, not just reasonable to you. You know, you have to really, others looking at the situation would say, yeah, that really is a direct threat to health or safety of others. And so if you're in my environment, you know, be it on the 3rd floor of my house or in the office, we're socially distanced, I have a separate desk, separate office. We're masking it up. We got the hand washing. We're doing everything we need to do. I'm not a direct threat to anybody unless I'm in someone's face and I caught it and I'm coughing or talking in someone's face. You're not going to make that case. On the other hand, if, for example, you're, I don't know, in a nursing home, you have nurses who are in close contact with many others, especially if many of the residents are immunocompromised, and you know, and also if there's evidence of outbreaks that have occurred, then you know, and if you're in there for more than just a moment or two, then and it's consistent, then you know, I think you might make the case that, look, there's a direct threat to the safety or of others in that workplace. And so, you know, but there's one extreme, there's the other extreme, and there's everything in between. And so really the benefit of looking at the case law and working through that case law, and then, just saying, okay, well, this is more akin to this case that we dealt with before, is really how that analysis is done. But, unfortunately, you're not going to walk away. Most of you probably won't walk away with a clear cut answer. There's no bright line rule. You just have to apply the facts of the scenario and really make that determination. And so getting advice is, and not just from internal to the organization. I think you may find that that's something that is a resource you may need to draw on to make that determination.
Right. Yeah. And realizing that every situation is unique. And if you're familiar with the ADA at all, you're familiar with the phrase reasonable accommodation. Obviously, the ADA existed way before COVID, and some of you might have had to make reasonable accommodations in the past for a variety of reasons that your employees have brought forth. You've engaged in that interactive process with their physician. The physician has suggested what a reasonable accommodation might be for that particular disability. And so in this case, Courtney, what if, and I don't know if this is happening yet or not, but what if they produce a doctor's note that says Leslie should not be getting the COVID-19 vaccine? Does that sort of supersede these 4 sort of yardsticks down here at the bottom, or is it still a conversation? I mean, I guess these yardsticks can also help determine what the reasonable accommodation would be if they can make one.
Well, then I think you get into a reasonable accommodation inquiry, and I think you let go of the first question about direct threat. I think you go to the second question, because if you decide, don't fight a doctor's note, please. Don't. And I know a lot of people, look, the employee goes to whatever pop-up shop, it's not, and you kind of question legitimacy of this nurse's note, and it looks like a form letter. And I get that all the time in ADA cases. And it's frustrating because you're like, really, I seriously doubt this person seriously considered all the factors. And I just don't necessarily believe that note. I don't, if you get into trying to fight doctor's notes or health practitioners' notes, it's usually not a winning. It's not really where you want to be. And besides, it's a practical matter. If an employee doesn't want to take the shot, they're going to find a way. It's going to happen, and that's just a practical answer. But I think you start getting into what is a reasonable accommodation, and I've litigated on this issue, and I've been in federal court on this issue, and in reasonable accommodation, I think you really do have to take an honest look. And if you have to get a third party look at what reasonable, if you say, I really can't have this person in the workplace, I think reasonable accommodation might include telework. It might include another position. It might include some kind of physical separation. You mentioned the scarlet letter and being viewed differently by others. But if there are ways that you can accomplish accommodations to keep that employee employed with you and accommodate them, I think it's a win for you, because if you just get into wrestling matches over individual refusals to vaccinate, you're going to get into really tough questions on exactly these 2 issues right here. So I'm not saying it's impossible. I'm just saying that I would be extremely cautious about if you get that doctor's note.
Okay. Good to know. So just expanding on this, the EEOC, this is a pretty long answer, but basically what they're saying is if an employer determines that an individual who cannot be vaccinated due to disability poses a direct threat at the work site, you can't exclude the employee from the workplace wholesale or take any other action unless there is no way to provide a reasonable accommodation absent undue hardship that would eliminate the risk. So I know, Courtney, there are going to be some people out there who say, that's great, but my people cannot work from home. I can't separate them. They have to be, the way that our, the nature of our business requires them to be close to one another or close to customers. And then, but yet somebody can't get won't get the vaccine and they have a doctor's note. What kind of options do they have in that scenario?
Yeah. So, the most important thing I think is I would not dictate, I would have a conversation, and it's meant to be interactive with the employee. And a lot of people miss that and they say, well, we have to do X and this is what it's going to be. I think you can have that conversation, and you also they may see some angles or some potential accommodations you don't see because they're closer to their job duties. And so, so have that have it as a conversation, and don't get into necessarily you don't have to necessarily know the diagnosis of the person to know if you can. Sometimes if I have a frustrated employer and we don't know exactly how to accommodate, I might actually, and they come back with some doctor's note that doesn't tell me anything, I might actually give them a copy of their job description. Say, would you please go back to your healthcare provider, give them your job description and tell them which of these essential functions can you not do. Narrow it down. I'm not asking what your diagnosis is. I don't need to know your health condition. I don't need your HIPAA information. I do need to know of these essential job duties which are on your job description. And by the way, if you don't have good updated job descriptions that include the essential job functions, and I highlight the word essential as opposed to preferred or outdated or whatever, so that when they come back and they say, I can do 1 through 10, but I can't do 11 and 12. Okay, now we can have a meaningful conversation back and forth about what the accommodations are. Good tips to use. And so focus it on the essential job functions, and then focus on alternatives, and then have it as a conversation with the employee. I think, I almost kind of consider it the nuclear option to say, oh, there's no way you can work here.
Yeah.
That might be an extreme example to say you really can't. And I'm not saying it's impossible, but I'm saying that if you really get to that point, then let's talk about accommodations in which the person is not necessarily terminated, and is still an employee, but is still accommodated in terms of their condition.
Right. And so what the EEOC is saying here is that you can exclude the employee from physically entering the workplace, but that doesn't mean you can automatically terminate them. I think maybe some of the cynics among us who are still suffering from a little PTSD from last year, where we had some folks who were able to take paid leaves and stay home and not work because they were under quarantine. I had a couple clients who were suspect of their employees trying to sort of work the system in a way so they could get basically a paid vacation. I'm not suggesting that any of you guys out there have employees like that, but we definitely had that scenario come up a couple, more than once in 2020. So, absence of a clear-cut answer or a bright line, like Courtney said, do your best to have that interactive conversation. Let the physician lead the accommodation suggestion piece. Make sure your job descriptions are up to date. And if you still get to a place where you just cannot come to an agreement around an accommodation, maybe it's worth, I don't know, Courtney, maybe it's worth consulting counsel at that point. I would hate for anyone to terminate anybody and take that nuclear option, and then face even worse repercussions later on.
Sure. Yeah. And if it starts to affect the conditions of their work, be it their pay, their presence, you name it. I get so many scenarios that could have been fixed had there just been a little bit more and better communication and interaction with the employee. And they don't necessarily have to like all the answers, but if they feel that there's engagement in a conversation, look, I'm trying to stave off litigation. So we get the benefit of seeing situations after they went bad. And if I get a time machine and get a chance to go back in time before it goes bad, I really do try to avoid the problem. And, the communication piece and getting buy-in with the employee is so important. That's not a legal thing, but that's just a practical thing.
Right. Okay. Yeah. Well, let's keep moving on. And we do have some questions in the queue, but I'm going to move on to the next slide before answering those. All right. So this is the exact same question, But this is for the different reason. This is somebody who objects to a vaccination because of a sincerely held religious practice or belief. So there are only two exemption reasons that the EEOC covers for now on its webpage. And I do know there are some of you out there saying, what if it's not one or the other? What if it's a third thing? So we'll talk about that in a second. But this is the exact same scenario, but now that it's not a disability, it's a sincerely held religious belief. And this is another area where the answer is long. And the answer is not necessarily yes or no, but essentially, once an employer is on notice that an employee's sincerely held religious belief, practice, or observance prevents the employee from receiving the vaccination, the employer must provide a reasonable accommodation unless it would pose an undue hardship under Title VII. Courts have defined undue hardship as having more than a de minimis cost or burden on the employer. EEOC guidance explains that because the definition of religion is broad and protects beliefs, practices, and observances with which the employer may be unfamiliar, the employer should ordinarily assume that an employee's request for religious accommodation is based on a sincerely held religious belief. That's a really important sentence because you really can't press too much farther on that. If somebody says they have a religious belief or practice or observance that prevents them from getting the vaccine, you really can't push back too hard on what that actually means, if I'm interpreting that correctly. If, however, an employee requests a religious accommodation and an employer has an objective basis for questioning either the religious nature or the sincerity of a particular belief, practice, or observance, the employer would be justified in requesting additional supporting information. And see, how do we reconcile that second paragraph and the third paragraph, Courtney? What are the options here for employers that are faced with this type of objection?
I would use a default mode of believing them. If someone expresses now look, if you think someone is just straight up lying and it's kind of obvious, sure, yes, you can ask for additional information. But but by default, I would tend to believe folks if they say I have a religious objection. I know people who have a religious exception to vaccines. I know them. It is, that's you have to honor it. So you can go ahead and have additional inquiry if you, but you kind of get into tough turf there by questioning a person's religious belief. And then again, look, if the case lands on my desk, I got to be able to prove it, and that's a really tough one to prove. I mean, and usually you have to have documents and, look, if you just can't prove that this is not a sincerely held belief, is it really something that, you're going to, is it worth it? Is it worth it? I think we're getting into talking about what's a reasonable accommodation. And now again, what's an undue hardship? Well, that really kind of depends, but if it's something that you can accomplish, then I think we have that discussion.
Okay, good advice. I realize that we're getting to the top of the hour here, so I just have a couple more slides and then we'll take the questions in the queue. Thanks for hanging in with us, Courtney, for probably going to run over here. Unless you have a hard stop, in which case I can roll through the rest of these on my own.
No, I asked for a few minutes extra.
Okay. All right. We'll be efficient. This is still on the same, hold on, did I not skip ahead?
You did.
Okay, I think I skipped back. Okay. All right. What happens if an employer cannot exempt or provide a reasonable accommodation to an employee who cannot comply with a mandatory vaccine policy? So this one is, we just sort of touched on it. This is what the EEOC says it would be lawful for you to exclude the employee from the workplace. But again, this does not mean that you can automatically terminate them. You'll need to determine if any other rights apply under the EEO laws or other federal, state, and local authorities. That is their answer there. in which case, Courtney, I would imagine they would probably need to consult somebody outside to see what their options are.
Yes.
Okay. Those are the ends of our official slides. We have a couple questions in the queue that we'll get to. And this is the one I was sort of hinting at earlier. If you have an employee who objects to getting the vaccine, even if he or she does not have a medical or disability exemption or a religious exemption, how do you handle it? So that's where somebody kind of falls in the middle. It's not disability, it's not religion. Can this person be fired or laid off until he or she gets the vaccine?
Yeah. Well, fired and laid off aren't the only options. I mean, there are, depending on your state law, there's unpaid leave. There might even paid leave. There are other options. And so, but definitely go back and take a look and say, is this something where, you know, they are going to check off those 4 factors in terms of being harmful to themselves or others at the workplace, or is it something that you can possibly work with? So my guess is that 9 times out of 10, you can find an accommodation, you can find a way for someone. But if you truly make it mandatory, then, you know, if they refuse, then perhaps, certainly I think get some advice and also figure out what are your dividing lines for that scenario. And I will tell you that in putting together a policy before you go in is important, and we're developing those now. And so this kind of contemplates all the scenarios, because we have thousands of employers that we're dealing with who are dealing with those scenarios. And so we kind of incorporate that into the policy. And the reason that's a great idea is because how you treat one is how you have to treat everybody. Anyone in HR, anyone who's been a boss knows that you have to treat everyone the exact same or you're in trouble. And if you have a policy on point that addresses that question, how you're going to, that applies to your workplace, that works for you, and then you go with it religiously, then you're getting yourself out of hot water in terms of most discrimination claims.
And if they are interested in assistance with drafting that policy, they can consult an HR professional. They might have in-house HR. They could consult counsel. We have Courtney's email address on the screen, which he volunteered to put up there. So maybe you could, maybe Courtney could give you some help. But I think that's great advice, to go ahead and get ahead of it. Even if the vaccine might be farther off for your folks than others, go ahead and get something in place so that you can, as a company, be ready, be prepared to address something. And that doesn't mean the policy has to be set in stone. We can flex, particularly if guidance changes in your state or locality. But just going ahead and having that there now is a great idea. Francesca says Courtney is the best. So there you go. I agree.
Thank you, Francesca. Hi.
Marty asks, how can we encourage employees to get the vaccine short of mandating? Is it okay to offer incentive? We touched on this a little bit earlier. Courtney pointed out, rightly so, that incentives can get you into a little bit of hot water, because then you're denying people gifts and money or paid time off or whatever the incentive is. And that's not necessarily where you want to be. But you could, like I said earlier, make it easy for them to get it. Allow them time out of the office to go get the vaccine during work hours. Lead by example. So if you're in the leadership team and you got your vaccine, make that known by, maybe take a video or do it on site, or, whatever feels right. What else, Courtney? Are there any other ways that you think that the encouragement piece can be there, if not required?
If a dark cloud just came over my head, it's because I'm thinking about what's going to happen a little bit later this month, which is a change of administration, at least federally. And so that's EEOC and that's OSHA. We already have an administration in Virginia that I think is disinclined to look at incentives favorably. We have seen this before, and I think OSHA may be going down the road of the current administration has been more embracing. The current OSHA administration has been more embracing in its tone of incentives. I think that will very well change. And I think that, again, good intentions of I'm getting a headache when I think about gift cards and money and recognition or anything that, especially tangible things given to people for getting a vaccine. I'm starting to think about, okay, will someone say that I wasn't compensated as well as others because of my religiously held belief? And I am thinking about administration and agencies that are going to look at that more from an employee standpoint.
Mhm.
And so we've had a very employee-friendly shift in terms of our statutory regulatory law in Virginia. And so I would be very cautious about it. So I hate to end with a dark cloud over my head, but when I think about
Yeah.
incentives, I start to reach for the Tylenol.
Yeah, no, that makes a lot of sense. Another thing you could do, Marty, is, have a, educational, educate your employees in a way that doesn't seem like you're, forcing it on them, but making available some things that you think are good sources of education around the vaccine and its efficacy, and, the without giving away my personal preference here, but how it could be something that's a widespread good thing for ending this pandemic.
Yeah, and I saw Francesca mention that Virginia Department of Health is going to do some town halls on vaccines soon, so that's good. And yeah, Leslie, when we were just talking before this, I agree 1,000%. And so, look, there are pockets, there are communities that have skepticism about the vaccine. We all know that, okay? And so, if you provide information, and also maybe there are subtle ways that you can try to let folks know that this is something that we encourage. And EEOC itself is saying encouragement of this is fine. And so I noticed that, the first nurse who received it, she's a member of the African American community, and there's some concerns that's one of the many communities that have expressed some concerns. And so, you mentioned maybe if a CEO or someone who is looked at others as a leader, if they receive a vaccine in a way, if they choose to do so publicly, there might be some ways to show people, look, this is a good thing. You're not going to get dinged. Well, it depends on your workplace, but you may send a signal that this is something that we're embracing, we're encouraging, we're offering support, and oftentimes providing information and then respecting choices if you can do so is a great and positive way to avoid litigation or dissent or any issues with your workforce.
Yeah, for sure. That's really good advice. Jane, our friend in North Carolina, hi Jane, she says, FYI, I am a medical practice. Our malpractice carrier has provided a declination form for those who refuse the vaccine. Huh, interesting. Okay.
California has some different requirements in terms of privacy. And so we have some folks who are very attuned to, I'm not in California, obviously, but we have some folks who are very attuned to what the California requirements are.
And I'm sorry if I misspoke, but Jane's actually in North Carolina.
Oh, I'm sorry. I thought you said California. I'm sorry.
No, I think I was mumbling. Sorry. She's in North Carolina. So it sounds like her carrier is providing this declination form. Interesting. Okay. Thank you, Jane, for sharing that. As always, we like to hear this information from our listeners. Anonymous says, I'm still not clear. In Virginia, can an employer require an employee to take any vaccine, including one for COVID? From the presentation, it seems that the answer is, quote, sort of. Go ahead, Courtney.
Yeah, the frustration I mentioned we would have is that we're going to walk away without all the clear answers, and that's one. EEOC has provided a path for potential mandatory vaccines, but EEOC is not the only player. Now, OSHA has not spoken on this. As far as the last time I checked, Virginia had not done so. Localities may do so. I'm not aware that localities in Virginia have done so. but this is something you have to kind of keep your eye on. And so again, if it eases frustration, we do have, I have a blog subscription that can alert people to when developments occur. We try to stay on top of these things and then and share that with people as developments occur from the agencies and in terms of the law. So, if that's a resource that's helpful to you. And, we are certainly trying to stay on track and stay on top of what those requirements are. But at this point, EEOC has provided a path, and that's so far what we know.
Yeah, I mean, the answer is yes, but you're putting yourself, there are definitely some things you have to consider as an employer that, it's just a more elevated situation if you require it. So yeah, and like Courtney said, there's definitely going to be some litigation and guidance that comes up in the coming weeks and months that might change things or reinforce things. Mike writes, we are currently closed due to positive cases of COVID in our private school, but plan on reopening January 11th. We have also just been notified that we will be eligible for the vaccine in very short order as we are considered essential personnel. As a private school, do we have any additional leverage to have our teachers and staff receive the vaccine other than strong religious reasons and pregnancy?
I don't know of any. I don't know.
Okay. So maybe consult with the your state organization, Mike, maybe your accreditation agency. I'm not really sure where to look for that. But I can put it down on our research list and perhaps we'll address it in a future webinar. Teresa says, can you provide us with the EEOC link in the Q&A of this webinar? Teresa, my friend Isabel, just put that in the chat. So we just put the link to our source information for today's webinar in the chat. The page covers a lot of different topics in addition to the vaccine. The vaccine specific questions are, if you scroll down to the K section, section K, I believe it might be the last section, and then keep that open and refresh it often and see if they update anything. Brittany says, when do we have to advise our employees of which policy we choose? Great question. I don't know that there's actually a best practice on that. Maybe as soon as you have it, written and approved, just to go ahead and get that information out there and be prepared to answer questions.
Yeah, I'd say when you're ready. And ready meaning that, we have a litany of questions that we go through to try to make sure, because there are landmines that we don't think that we may not think of in your situation, but the benefit of dealing with thousands of situations is that you can take the collective wisdom of all of them and build that into your policy. So I treat it kind of like I treat writing a brief. When they ask how long should it be, it should be the length that you need to get it right. And I think that goes for your time frame as well. And I would want to make sure that we've gotten it right before you roll something out.
All right. Katie asks a question that we've pretty much addressed, but at this point, is it still up to the employer to make the vaccine mandatory? Is there any negative kickback on the employer for not mandating the vaccine? We touched on that a little bit earlier, and we don't know that second question. We're not sure about that liability piece right now. Yeah,
I mentioned the workers' comp piece that's out there, but that is still something we're tracking. There are thousands of lawsuits filed against employers over COVID around the country, including Virginia, and so we're tracking those. But honestly, a lot of that case law is not yet developed. So I commented on the work comp piece, but plaintiffs' lawyers are creative creatures. And every once in a while, one of them gets lucky with an argument that nobody thought of before. But we're tracking that, but I don't, other than what I said before, I don't have any additional information.
Okay. So just as a recap, Courtney said before that the Virginia's Workers' Compensation Commission is not prone to blaming the employer for a contraction in the workplace because this is a community spread
Rare
disease.
disease of life.
Yeah. Katie, I hope we answered your question. Teresa has a great question. Which law or agency allows employers to make the vaccine mandatory for employees?
Anything that touches your workplace. So OSHA touches your workplace. VOSH under OSHA touches. EEOC is there. And so, and for many of you, Virginia Department of Health. And certainly the CDC guidance is the font from which a lot of this other stuff flows. And so when I want to see where things are going, I keep my eyes focused on CDC.
Okay. I mean, I haven't seen anybody saying that employers can't make it mandatory either. So there's sort of that flip side of the equation. Like we've said all along through this webinar, you can do it. No one's saying you can't, right? It's just there are definitely some serious considerations to factor in.
Yeah. And it's often overlooked that the states and the localities can come up with their own requirements that don't apply anywhere else. So that's something else we're keeping an eye on.
Okay. Marty says, with respect to having, giving employees time to get the vaccination, could you let them stay on the clock to get the vaccine, or is that also discrimination against the people who don't get the vaccine?
Can you give them time to go and get the vaccine? Is that what the question is?
Yeah, can you pay, would someone who abstained from getting the vaccine see it as discriminatory if someone else gets compensated for the time it takes to go get the vaccine?
So the vaccine itself, if it's employer mandated, would be paid for or compensated by the employer. There is not clear law in terms of requirements of paid leave, which is not exactly what that question is. The question is kind of the flip side of it, which is, can someone say someone else got paid leave and I got discriminated against because they got paid leave to take it?
Right.
I haven't seen a case like that. Boy, that would be a tough case to make, I think. I wouldn't want to be the lawyer arguing that there's discrimination for not taking the test because someone got an hour to go take it somewhere else and come back.
Yeah.
That sounds like a really tough case to make.
So should they not compensate them for that time then? Or is it, because what I was saying earlier was, make it easy for someone to go get it. But I guess what you're saying is if it's not required, then maybe they don't compensate them for that time.
So far, I haven't seen hard law that requires paid leave for taking the vaccine. Keep an eye on the General Assembly. I think that and some other questions may be answered by the end of next month. But so far, we don't have hard law on that.
Okay. Thomas says, sounds like this person knows you. He says his name is Thomas Galozin. I might have mispronounced that.
Oh, yeah. Hey, Tom.
Courtney, great hearing from you again since our OAG days. Since there are several vaccines out there, one of which may not be using with fetus cells, can an employer mandate that one is taken but give the employee the choice within a reasonable time frame?
In terms of choice of which vaccine to take?
That's how I'm reading it.
I see no law on that question at this point. That's a question that I just don't have an answer to.
Okay. So right now, a vaccine is a vaccine is a vaccine, I feel like, in terms of how employers consider it. Unless you're in the healthcare industry, I mean, like you said earlier, you might have, if you're a healthcare provider, you might have a different perspective on that. Or if you have a licensed provider who's administering the vaccine, what vaccine you choose to administer might be based on your medical expertise. I don't know. I'm not really sure.
Yeah, that's
yeah.
Tom always thinking ahead.
Thanks for stumping us, Tom. Okay, Jane, our friend in North Carolina, says that the declination form from her malpractice insurance provider clearly outlines all of the risks associated with failure to vaccinate. That's interesting.
Mhm.
Okay, so that's one way to educate employees. Thank you for sharing that, Jane. Tom's back and he says, can an employee request the employer to allow the employee to work from home instead of getting the vaccine?
Yeah, we're getting to reasonable accommodations. And so many of us are familiar with reasonable accommodations, maybe not as that question, but rather the new normal, which is, working from home or finding new ways to work in terms of exposure. So, and that may educate us in terms of what is now reasonable accommodation. So it very well could be a reasonable accommodation, especially if it's something that people have been doing. They haven't been doing it in all workplaces, but they've been doing it in many.
Mm-hmm. I mean, I would argue that, the virus is still with us, guys. So if I've always said, you guys who are regulars on here know my stance. If they can work from home now, regardless of their stance on the vaccine, it's probably best practice just
Mhm,
because we're still in this.
mhm.
So there's that as well.
Yeah. Well, good. If you think we've substantively gotten through them, I've asked for a few minutes extra, but I think I'm kind of
You pushing
getting to
it?
a point where,
Well, Courtney, we're so happy to have you here with us today. And thank you so much for staying a little later. For those of you who are still on the call, here's Courtney's, again, his contact information that he willingly provided to us. So Courtney, we are so grateful. And as always, it's great to talk to you and pick your brain about these issues. I'm sure it won't be the last time you'll hear from us at Dominion Payroll. And we thank you and your partners at Jackson Lewis for all the good work.
thank you for having me. Appreciate it. And again, if there are questions, I can turn to others. And so there are many who've been dealing with this in many of the states and have gone down paths that I have yet to go down. So I might be able to help you to resolve your questions and your situations through the resources of the firm, in addition to myself. So thank you so much for the opportunity. It's been a pleasure.
Thanks, Courtney. Have a great afternoon.
Okay.
Take
Bye.
care. Bye, everybody.